Pandi. Hello students, welcome to Epitome IAS. So as you know very well, we have started a series of videos, live classes to train the students in the answer writing process. And today this question is about Constitution Amendment. Constitution Amendment is right. So this is one of the important questions every time you can expect in the examination, particularly in the context of the checks and balances between legislature and judiciary, right? So what is this question about? Indian Constitution conferred the amending power on the ordinary legislative institutions with a few procedural hurdles, okay? In the view of this statement, examine the procedural and substantive limitations on the amending power of the Parliament to change the Constitution. Right. So we need to write introduction, body and conclusion for this answer. Okay. Right. So first of all, what is see, introduction must be having the idea about Constitution Amendment. Introduction. So you don't require to write introduction in the examination, just for the sake of understanding I am telling you. Right. So we need to understand what is the basic question it is talking about. It is talking about the Constitution Amendment. Hence, we require to write, we need to begin the answer with what is Constitution Amendment, right? So, Constitution Amendment means adding, repealing and making any variation to the provisions of the Constitution. Provisions of the Constitution. So this is so, and it is mentioned under Article 368 of the Constitution. It is mentioned under Article 368 of the Constitution. Right. So this is how you write introduction. So Indian Constitution conferred amending power on the ordinary legislative institutions, right? So we can write some other point because it is 15 marker question. So naturally we can increase the size of introduction here. Since the Constitution is a living document according to Dr. B.R. Ambedkar, it has to undergo changes periodically to reflect the requirements of the society. So this is how we can understand. We can write any other point, requirements of society or requirements of administration or requirements of governance. You can write any point appropriately. Okay, right. This is what introduction. This is what the context of the answer. Right. Then what is the point here? Amending power has been conferred on the ordinary legislative institutions. Okay, right. So what do you write? So you need to address these two dimensions here. This is the first dimension and this is the second dimension. Okay, right. So coming to the first dimension, right, we need to write how the Constitution has given the amending power to the ordinary legislative institution. Okay, right. So for that reason we need to write these points. Indian Constitution has conferred the power to amend the Constitution, to the Parliament itself. Unlike the American Constitution, which has provided an option for Option for Constitution Convention. Constitution Convention. So either the Congress can amend the Constitution with the ratification of the states in America, or there is a possibility for the establishment of Constitution Convention, right. So it means in India we did not want to create any particular institution, okay, to amend the Constitution. So Parliament itself is having the power to amend the Constitution, right, right. So the question here is with procedural hurdles, okay. So it means in India we can say, the point we need to explain here is the ordinary legislative institution itself is amending the Constitution. Ordinary legislative institution itself is amending the Constitution. So which means in India, thus in India we can say, thus in India the amendment of the Constitution reflects, amendment of the Constitution reflects an ordinary procedure, ordinary legislative procedure, ordinary legislative procedure. How it is reflecting the ordinary legislative procedure? We need to write this point, right, in terms of, right, in terms of introduction of a bill where both public member and private member, okay, can introduce the bills, okay, right, and no requirement of prior recommendation of president, no requirement of prior recommendation of president, and to be introduced the Constitution Amendment Bill can be introduced both in Lok Sabha or Rajya Sabha. So it does not require to be introduced only in one house, okay, it can be introduced either in Lok Sabha or Rajya Sabha. And next important thing is the presidential assent, okay, the presidential assent. This is how you can see the Constitution Amendment features, in fact. So these are all similar to that of the ordinary legislation itself. So there is no mention about, special institution, special body for the amendment of the Constitution, right. But however, it is having certain procedural hurdles, right. You must understand what he mentioned, with certain procedural hurdles. So how the procedural hurdles are there, right. So the procedural hurdles are reflected in the form of, what is that, majorities, okay. So particularly Article 368 says that in order to pass the Constitution Amendment Act or Constitution Amendment Bill, okay, what is required? Special majority is required. Special majority is required, okay. And the special majority has two implications, right. One is to amend the non-federal features of the Constitution. One is to amend the federal features of the Constitution, okay. In order to amend the non-federal features of the Constitution, we require to have majority of 2/3 among members, 2/3 majority among members present and voting. This is what, right, for the amendment of non-federal features like fundamental rights, directive principles of state policy, preamble, so that kind of features can be amended, okay, right. Whereas to amend the federal features, what is required? So along with this majority, along with this 2/3 majority, that is 2/3 majority among members present and voting, plus ratification by half of total legislative assemblies. So this is how the procedural hurdles are there. So this ratification is by simple majority. So in this way we are able to address the first part of the question. So the first part of the question is The Indian Constitution is given the power to amend the Constitution through the ordinary legislative institution itself with certain procedural hurdles. Right. This is how we have written the first part of the answer. Right. Then what is the second part of the answer? In the view of this statement, examine the procedural and substantive limitations on the amending power of the Parliament. What are the procedural and substantive limitations? So we have covered the what is the procedural limitation. So this is how. So the procedural limitations can be further elaborated, like for example, over the Constitution Amendment Bill, no scope for suspensive veto. Okay, and not only that, Constitution Amendment is nothing but it is not ordinary law. That is according to Article 13 Class 4 of the Constitution. Even Article 368 Class 3 of the Constitution also speaks the same. Constitution Amendment Act is not law, okay, ordinary law. So no judicial review is available. So this is according to the Constitution, okay. So we need not write judicial review just to negate this point. We can mention as it is, right. This is what the procedural hurdles, okay, right. Then what are the substantive limitations? In the view of this statement, examine the procedural and substantive limitations on the amending power of the Parliament. So what are the substantive limitations? Okay. So substantive limitations means what? This can be understood in the light of judicial interpretations. Judicial interpretations. Okay, right. So actually the question is whether the amendment power of Parliament is limited or unlimited. Okay. So how to amend the Constitution is one question, and second question is whether the amendment of the amendment power of the Parliament is limited or unlimited, right. So this question has arisen in the case of various cases. For example, Shankari Prasad case, Sajjan Singh case. Okay, in both cases, the Supreme Court has upheld unlimited power of the Constitution, unlimited power of the Parliament to amend the Constitution, right. Later, these particular cases have been challenged in the other cases, such as Golaknath case, right. Golaknath case. You don't require to explain every case in detail, but you need to make some reference. Okay, Golaknath case. In Golaknath versus State of Punjab, what Supreme Court said was, Parliament does not have unlimited power to amend the Constitution. In fact, the Constitution does not mention whether Parliament has the power to amend the Constitution under Article 368 or not. Particularly Article 368 actually provided for the procedure to amend the Constitution. Not power to amend the Constitution. This was highlighted by Supreme Court in Golaknath case. Then what happened? This was actually Supreme Court also said, in fact, Constitution Amendment Act is ordinary law. Why? Because when the Constitution does not specify whether the Parliament is having the power to amend the Constitution or not, definitely that should be assumed as ordinary legislative power. Since none of the lists in the 7th schedule mentions about the power to amend the Constitution, we need to consider that power comes under Article 248 of the Constitution. That is what residuary power to amend the Constitution. So residuary power of the Union Parliament is something which is nothing but ordinary law. So hence ordinary law is nothing but Constitution Amendment Act is nothing but ordinary law. Hence there is a scope for judicial review by the Supreme Court and High Courts. That was a judgment given by the Golaknath case. But however, Parliament has amended the Constitution again by 24th and 25th Constitution Amendment Acts. These have amended the very important provisions of the Constitution. Particularly, the amendment related to Constitution Amendment is that is 24th Constitution Amendment Act of 1971. Right? This Amendment Act has amended both Article 13 of the Constitution, Article 368 of the Constitution by adding Class 4 and by adding Class 3. and particularly Article 368 also has been amended to add the term called as power. Okay, right. So this is how Supreme Court said. I mean, Parliament has said in its amendment that ordinary law is not a constitutional amendment. Hence, no judicial review. No judicial review. Right. This is how the Parliament tried to assume ultimate power to amend the constitution or unlimited power to amend the constitution. Why? Because when you say judicial review is not available, so simply the intention behind this amendment is Parliament must have unlimited power to amend the constitution. So any provision of the constitution is open for change by the Parliament. So that is what the intention that was reflected by 24th Constitutional Amendment Act. This is what the context, okay. We need to briefly mention this. Then what Supreme Court said in Keshananda Bharti case. Later what happened? 24th and 25th Constitutional Amendment Acts have been reviewed by Supreme Court in Keshananda Bharti versus State of Kerala, right? So 1973. Okay, you don't require to write much about this, but you need to write as a reference, okay, because our primary focus must be rested upon this aspect of the question. What is it? What are the procedural as well as substantive limitations on the amending power of the Parliament to change the constitution? So we have discussed what are the procedural limitations. Now what we require to discuss is what are the substantive limitations. In that context, we cannot directly come to the substantive aspects, rather we need to mention some facts regarding what are the problems with respect to this particular amendment of the constitution and what were the basic Supreme Court judgments and amendments. Thereafter we will have to mention. So now Supreme Court in Keshananda Bharti versus State of Kerala held that power of the Parliament to amend the constitution cannot be unlimited. Cannot be unlimited. It means Supreme Court has clarified whether the Parliament has the power to amend the constitution. Supreme Court said yes. Whether any part of the constitution can be amended, Supreme Court also said yes. In that context only preamble can also be amended. The Supreme Court has clarified, right? So that's how Parliament has power to amend the constitution, but this power cannot be unlimited. So Supreme Court has emphasized this particular point in the form of basic structure doctrine. Basic structure doctrine, right? So what is basic structure doctrine? Supreme Court did not define what is basic structure doctrine, right? But actually Supreme Court tried to showcase certain features which can be reflecting the basic structure doctrine. So Supreme Court did not want to define exactly, but however basic structure doctrine entails the basic or fundamental elements of Indian Constitution, okay, which are crucial for the spirit or philosophy of Constitution, okay. Those basic or fundamental elements of the Indian Constitution which are crucial for the spirit of philosophy of the Constitution or purpose of the Indian democracy. Purpose of Indian democracy. What Indian democracy tries to achieve. What are the fundamental elements of the political lives of the people. So those are reflected in the form of basic structure doctrine, right? Right. So it means you cannot change such elements which form the essential features of the Indian democracy, essential features of the Indian Constitution. So those are not open for the change, okay. So that's how Supreme Court said if any basic element is violated, that definitely be open for judicial review. But Supreme Court has upheld Constitution Amendment Act is not law, yes, as it was inserted under Article 13 Class 4 and Article 368 Class 3, that's okay, it has been upheld. But what Supreme Court said, yes, you can use this power constructively to enhance the features of the Constitution, to enhance the value system of the Constitution, to expand the rights. But however, you cannot use this power to amend the Constitution in a regressive manner. That is explained in the form of basic structure doctrine, right? Supreme Court has given certain indicative features, right? Any constitution amendment shall not be violating certain aspects. For example, supremacy of the constitution. Constitution is supreme, no other institution. And republican feature of the constitution, secularism. Okay. Similarly, socialistic features. Okay. Separation of powers. Okay. Right. This is how various features have been listed. Okay, but not exhaustively. Not exhaustively. Why? Because if you mention everything exhaustively, what will happen? Parliament will find another means to amend the constitution. Okay. So simply if you clearly mention these are the basic structures or basic features, definitely, certainly Parliament will find a new method to amend the constitution to violate such features which are mentioned in the basic structure. That's why cleverly Supreme Court has followed a wait and what is that, till the time the Parliament amend the constitution, the Supreme Court will be it will be watching. The moment what will happen, the constitution has been amended in the negative manner, in the violation of the basic structure, then again Supreme Court comes up with the judgment that this is the violative of basic feature of the constitution. Right. So it means the Supreme Court in various cases, Supreme Court case after case, started emphasizing upon basic structure, like Minerva Mills case. Judicial review is a basic structure. S.R. Bommai. Secularism is a basic structure. Okay. Similarly, fourth judge's case, judicial independence is a basic structure. Okay. So even in this particular Quixote Holahan versus Jachulu case, okay, judicial review and judicial independence, okay, these are the basic structures. This is how Supreme Court has expanded the concept of basic structure in case after case basis, right. So we need to understand this particular question in this way, right. First of all, we have written introduction, later we have written how the constitution amendment process is through ordinary legislative institutions and what are the procedural hurdles we have mentioned, and we are trying to talk about the substantive limitations. So it means the constitution amendment cannot be destructive of the basic structures of the constitution or basic features of the constitution, and rather the constitution amendment must be constructive. So we can write this way, okay. So which means the constitution amendment must be constructive, okay, must be constructive. In what sense it must be constructive? Okay, so constructive in the sense what? The amendment is for the maximization of benefits for the people and constitution. Okay, it must not be in violation of constitution. Constitutional value system must be enhanced. Okay, the constitutional protection must be enhanced for all the vulnerable sections. For example, you take 86th Constitution Amendment Act. It has added Article 21. You can write these points. You need to write these points continuously. Okay, 86th Constitution Amendment Act has added Article 21A, 51A, Class K, and Article 45 has been amended. Article 45 has been amended. So this is how you had tried to provide a new right called as right to education. So it is what? Constructive. You try to provide new rights. Okay. Similarly, 101 Constitution Amendment Act, 101st Constitution Amendment Act has added Article 279A. This is what GST Council, new institution has been added. So which means, is it expanding, is it strengthening the federal feature of the constitution? Yes, because in the GST Council both states and center are the members, and they will be having the active consultation in order to formulate the what is the taxation policy of the country, that is GST. Okay, so this is strengthening the value system. Similarly, if you try to see other amendments, for example, 106th Amendment Act, okay, which has provided women reservation in the Lok Sabha, so and state legislative assemblies. Okay, this is also enhancing the value feature of the constitution. Suppose you take this has strengthened Article 15 Class 3 of the constitution, special provisions for women, of course children, so particularly women is considered here. So this is how you try to strengthen the value system of the constitution, right. So we can see many of such dimensions like 97th Constitutional Amendment Act, particularly amendment to Article 19 Class 1 Subclass C as well as Article 43B. So these have created a new provision for cooperatives. So you try to expand the system of governance by including the cooperatives. So this is done in the light of the liberalization, privatization and globalization. So that is how by means of the amending process you try to reinvent the governance in the country, expanding the rights, establishing new institutions, expanding or exploring new dimensions for the governance. Particularly you can also look at Article 39A of the Constitution, which talks about establishment of institutions and enactment of laws to provide justice on the basis of equal opportunity. So that is nothing but freedom, free legal aid. What is it? Free legal aid. Okay. So this is also done through Constitutional Amendment Act, that is 42nd Constitutional Amendment Act. This is how you want to amend the constitution in a constructive manner, right. So new institution, for example tribunal system, okay, part 14A, okay, Article 323A and 323B, okay, this is also a constructive thing, right. But which amendment is generally what is that struck down by the judiciary in the name of basic structure? Those amendments which go against the fundamental features of the constitution. For example, in the Supreme Court in the Minerva Mills case, Supreme Court held that the amendment to Article 368, particularly Class 4 and Class 5, these have been struck down. Why? Because they tried to confer unlimited power to amend the constitution. No court can question. That is what the language of 368 Class 4 and Class 5. So Supreme Court said this is against the concept of judicial review. So these two amendments have been added by 42nd Constitutional Amendment Act. Even 42nd Constitutional Amendment Act has also amended the Article 226 of the Constitution by including Article 226A, where high courts cannot question the union laws. So of course this was repealed by 44th Constitutional Amendment Act, right. This is how, this is what the substantive aspects, substantive limitations upon the power of the constitution, power of the parliament to amend the constitution. So we need to understand, we need to clearly differentiate. So procedural hurdle means what? Substantive hurdle means what? So procedural hurdle means procedurally, okay, procedurally, that is nothing but method. As in the dimension of method, what can be the limitations possible? So method wise the limitations are, the method wise the limitations are special majority is a limitation, okay, and equal rights, equal powers for Lok Sabha and Rajya Sabha, either to pass the amendment or reject the amendment is a procedural safeguard, and no provisions for joint sitting is a safeguard, and both public member and private member has to introduce the constitutional amendment bill is one of the safeguards. It means it is not necessarily the minister has to introduce, it can be the private member also, and not only that, even presidential prior recommendation is not required. That means any member can introduce the constitutional amendment bill. As far as the majority is concerned, it is a special majority. These are what procedural safeguards. Okay, and coming to the substantive means the purpose. Substantive means the purpose. The purpose for which you try to amend the constitution is called as substantive safeguard. For example, the purpose is nothing but it should be in line with constitutional spirit. Okay, so any amendment shall not be violating the philosophy of the constitution, that is nothing but basic structure of the constitution. Basic structure is the limitation. So constitutional amendment must be constructive. Okay, constructive in the sense what? Expanding the benefits of the constitution for all the sections. You try to bring new sections, you try to bring new provisions which will be having the effect of expanding the present safeguards for various sections. Okay, that is how. That is what the substantive limitations. Right. This is broadly we need to go with. Right. So I think we have addressed all the dimensions. So the amending power is vested with the ordinary legislative institutions. We have mentioned this. We have mentioned procedural hurdles, and in the view of this statement, examine the procedural as well as substantive limitations on the amending power of the constitution. So we can also mention certain judgments, okay, which has invalidated certain provisions. Okay, so we have mentioned about Minerva Mills case, right? So we can write certain examples. Okay, the Supreme Court, using its judicial review power, has invalidated few aspects or amendments. Okay, example, Minerva Mills case, just now we mentioned Minerva Mills case, where Supreme Court has invalidated certain aspects of 42nd Constitutional Amendment Act, particularly Article 368, Class 4 and Class 5, and it has said that that invalidation is upheld because it has violated judicial review. Okay, judicial review is basic structure of the Constitution. Right. Similarly, we can say Quixote Holahan versus Jechulu case, in which Supreme Court has reviewed the Anti-Defection Act, where it was invalidated that the Speaker's decision is open for judicial review. So previously, Speaker is ultimate authority, that was invalidated, and Supreme Court has exercised the doctrine of severability. Only particularly the Speaker related provision was invalidated, and rest of the Act has been continued. And moreover, we can see 99th Constitutional Amendment Act, where Supreme Court has completely invalidated the entire amendment because it has violated judicial independence because of the executive involvement in the judicial selection process, right? So that is how there are various amendments which have been invalidated by the judiciary by citing the violation of the basic structure of the Constitution, right? So then we need to conclude the answer. Okay, so that's how we can write. Okay, in the conclusion, Constitution amendment must be driven by both procedural and substantive aspects, where Parliament shall not become an arbitrary institution to amend the Constitution to disturb the delicate balance of powers in the Constitution. Delicate balance of powers in the Constitution. Apart from that, the amendments shall not violate basic structure of the Constitution. As propounded by Supreme Court. Okay, so this is the core point here. It shall not become arbitrary institution to amend the Constitution. Both procedural and substantive safeguards are preventing the Parliament from becoming an arbitrary institution or a despotic institution. So it cannot assume all the powers of other organs, okay, in the process of amendment of the Constitution, right? So basically, when you are writing these points, we can also make some comparisons also, right? For example, you can mention about particularly about Parliament of UK. Okay, you can make the reference of Parliament of UK, right? Unlike Parliament of UK, so how Indian Constitution, see, you understand, Indian Constitution with respect to Constitution Amendment shares both features. One is features of UK, features of USA. Okay, what is the feature of UK? The feature of UK is simple, that in UK there is no special institution to amend the constitution. There is no special institution to amend the constitution. But what is there in UK? Okay, there is Parliament of UK, Parliament. The Parliament alone can change the constitution. In fact, in UK, every ordinary law has a significance of constitution itself. There is no clearly written constitution. There is no special document called as constitution. Every ordinary law can be assumed as a part of the constitution itself. So hence there is no special institution in the UK. So similarly in India also there is no special institution. But however, we also have the features of USA. Features of USA in terms of procedural aspects as well as of course substantive aspects, but in USA that power of amendment has not been misused. Okay, so procedurally and substantively it is reflecting that of USA. Why? Because USA has its own constitution and Indian constitution has distinctive aspects. Okay, what is a distinctive aspect? The distinctive aspect is the constitution amendment can be more flexible compared to USA and rigid compared to UK. So it is having the mixed features. So this kind of comparison can also be made when you explain the main answer, okay, the body of the answer. Okay, right. This is how we need to write the answer. Okay, I hope you got the basic understanding how to write the answers. And if you have any queries, please place in the comment box. You can also improvise the answer by giving your own inputs. And for any queries regarding answer writing skills and other things, please contact Epitome IAS. Thank you.